Well, welcome back to the Cordell Cordell Virtual Town Hall. I'm Scott Trout, CEO and Managing Partner of Cordell Cordell. And as we do each month, we bring this virtual town hall to wherever you are so that you can ask questions and hopefully get some guidance, get some direction, talk about getting some answers, but always keep in mind that we can't give you legal advice. This isn't intended to do that. It's not intended to replace an initial consultation, which is the only place that you can get proper legal advice, legal guidance. And if you don't know how to do that, send you to the website, cordellcordell.com, and you can schedule a consult right there from the website. Don't even need to pick up the phone. You can put in your zip code, find offices near you, and you can schedule consultation. Now, if you'd rather just pick up the phone, you can give us a call, 866-DADS-LAW. 866-DADS-LAW. I'll be reminding you through today's 30 minutes as we go through today. Now, keep in mind, we'd love to hear from you, love to give you some guidance and direction. You can submit your questions in the Q&A section right now. We'll get to those here briefly. After we do, we're going to talk a little bit about child support for children who are getting ready to graduate high school, which is coming up. And then we'll get to the questions that we have already submitted and hopefully answer some of yours as well. Again, when you do submit your questions, just give us your first name, give us the state or city that you're in, because we're joined by two guests and we'll try to make sure if we can get them in your state, that'd be great. But let me introduce those two guests for you today. They're both attorneys with Cordell Cordell. Introduce Samantha Miller up in Omaha, Nebraska. Welcome, Samantha.
Thank you. Thank you for having me.
Yeah,
I've been with Cordell for about 3.5 years now, and I'm licensed in Iowa and Nebraska. So our Omaha office, we kind of handle cases mainly in Potawatomi County, which is Council Bluffs, Iowa. And I've been doing family law for about 7 years now.
Great. Thanks, Samantha. And then rounding out today's virtual town hall is Kellan Potts, a transplant from Tennessee up into New York. Welcome, Kellan.
Thank you, Scott. Pleasure to be here. As Scott mentioned, I'm licensed in both Tennessee and New York, currently practicing out of our Buffalo office. I've been with the firm about 3.5 years, same as Samantha. I think we started around the same time, actually. And I've been practicing family law for 6-7 years as well.
Great. Well, again, don't forget to submit your questions in the Q&A section. Would love to see what you have questions and you're worried about, and we could get those again. If you'd rather submit or do a consult, that is the only way to do it. And to get proper advice, and that is cordellcordell.com. We're going to get to a topic that I mentioned, child support around high school graduating. I think that's an interesting topic. We're just going to spend 5 or 6 minutes talking about that because it's coming up. It's the season. If you have children who are graduating, I know you want to listen. It matters and it varies state to state. But let's take a real quick look at a message and we'll be right back.
Fathers play a critical role in a kid's life. That doesn't change for single fathers. Cordell Cordell is dedicated to protecting that role because we are a champion for fathers' rights. Kids count on fathers. Fathers can count on us.
All right, welcome back. Okay, let's get going here. Samantha and Kellan, and I'll go to Samantha first. We were talking off air briefly about this topic because I'm getting a lot of questions about this from clients, past clients, and future clients, obviously, about they have a child who's graduating high school. They're getting ready to go to college. And the question always becomes, do I keep paying child support? I'm paying, for example, in Missouri. I'm licensed in Missouri, Illinois, and Georgia, but here in Missouri, there is an obligation for divorced parents to pay for college, which is an unusual part of the law. And obviously they take into consideration the ability to do so, but there is that obligation. And so you have this phenomenon where if your child goes away to school, lives on campus, now you're obligated to pay tuition, room and board, and perhaps child support, more room and board at a home, whether you have custody or the other parent has custody, you're paying almost double child support. So the question always becomes, what do I do? Can I get a discount? Can I stop paying child support? What happens when they go away? And even probably in a worst case scenario for a paying parent, that is, what happens if they never come back home? They live in for example, let's just assume for the moment they go to Chicago. They go to school in Chicago. Their home is in Missouri. they decide to live full time in Chicago, work, go to school. In the summer, they stay and they never really return to other than for temporary moments. It does create that issue, that conundrum, because in Missouri, you're going to pay child support until age 21. So Samantha, we were just talking off air. Why don't you kind of fill us in what the age of emancipation is in Nebraska, Iowa, and kind of what's your experience at that issue and what are you finding?
Yeah. So this is a very good question because it comes up often. I think the biggest concern behind this question for the parent that's paying, so in my case, typically the father, the question stems from, well, I don't want to pay child support to the child's mother when the child is no longer living with her. So how do I know that my support is going to this mother or going to the child? So the short answer is that in Nebraska, you must pay your child support until that child reaches 19. So the first of the month following when your child reaches that age is when your child support will end. And in Iowa, it's age 18. So there's a little bit of a difference there. Now, many kids are going to college before 19 years old when they're 18. Typically is the age. So the answer is that you are going to have to continue to pay that child support through that age of majority. Now, there are exceptions to this, definitely. And my best advice is that if there isn't a reason like the child has been emancipated legally, or if the child hasn't been married, those are reasons legally why child support would terminate. But what I direct the client to do is you can work with child support services to have that child support payment directed right to the child. So it's bypassing the other parent at this point, going directly to the child. So it's going to the child's using it for whatever his or her needs are. So that's the most common question I have is, well, I don't want to pay it to the mother. I don't know she's using this for my child. So the easiest thing is to direct it right to your child. Now, it's not very common that kids get legally emancipated and moving out or moving in with someone else, going out on their own after high school doesn't necessarily mean they're emancipating themselves. Now, there are some arguments to be made in Nebraska. I've seen where people will argue my child is self-sufficient, the child working, the child is getting their own money. At that point, there's an argument that's similar to emancipation, and a parent can't fight for that. But once children are out of high school, they're several months away from 19. The best advice is just it's going to cost less to just pay it through those several months until they are that age, instead of trying to fight it and trying to terminate it. The best advice is to ask child support services to direct your payment to the child so that it's going to the child.
Yeah. And I've been all over the board with this just simply because we go to 21, where I've even had a child who is working full time and going to school. And let's just say mom is not sending any money whatsoever to the child to help contribute towards food, board, whatever it may be. And so it really makes that case even stronger to either redirect some money or just stop paying. But Missouri is just a unique state where you have that ability, particularly in the county which I'm in St. Louis County, where the judges are very receptive to that behavior and that request. And that is to reduce, at least during the 9 months that the child's away, or to redirect. And so, Kellan, kind of what are you seeing? What's up in New York in terms of the emancipation age in Tennessee?
Sure. And I think this is a great question because it highlights how different each state can be. For example, in New York, just like Missouri, child support goes until the age of 21. Unlike Missouri, however, New York does not upfront require college contribution from either parent. Can happen, but it's not required. So I get the question a lot, Scott, as well. Well, my child is off to college. They're not living with mom. New York, for example, has a specific statutory requirement that going off to college does not stop child support. You can make the argument, as Samantha said, and I think it's really important for everyone to know that your case may be different than anybody's cases you've ever spoken to about this. I think it's highly crucial to, schedule consults, talk to attorneys, you can call us because it's a fact by case basis, right?
Mhm.
Tennessee, for example, child support stops at 18 and when the child graduates high school. So it's whichever one occurs later, when that happens, child support stops. There's no college contribution. So depending on what jurisdiction you're in, I think could highly change your specific facts. If, as Scott said, there's money that's going to a parent that's not being passed along to the child who's an adult, maybe away at college, I think there's always an argument there for a judge. Judges have a lot of leeway in these situations to determine what is in the best interest of the child. I think universally, you're going to come back to that. What is in the best interest of this child? And that depends heavily on what state you're in and the facts of your case particularly.
Yep. So it is, I think you make the good point, is have a conversation, see what your state, your jurisdiction applies or provides for you to do. I was just giving this advice to someone I know here in Missouri, and now it's deciding whether we should move forward. Kind of the cost benefit analysis. We have 3 years left. What is the child support amount? How much will we spend in legal fees to get it done? Because most of the time it's a contested, it's not settled. No one, typically mom's not going to want to give up that money. So, all right, keep your questions coming in the Q&A section. So let's just get to some of the questions that we have. We'll go to Samantha. This is from Mike. Mike is in North Carolina. Mike's spouse took most of their cash savings and purchased a $300,000 condo in South Carolina. She put it in her name only. Since she paid cash, my permission was not needed or was requested. Might that be considered theft? So curious your thoughts, Samantha. I know off the top of my head, it's typically, yes, you paid cash, but most of the time, title companies typically ask, is there a marital waiver involved? Are you single? Are you married? They're going to title it that way. There's some questions about whether or not you're going to proceed down the road to divorce and whether or not it's considered a marital asset, because thinking about anything in Missouri, particularly acquired during the marriage, is marital property. But Samantha, what do you say?
That's an interesting question. I think a lot of it stems from what are you getting to? Are you going through a divorce? Are you going to be filing for divorce soon? And how do you deal with this new property that now is part of your marriage? So as to the specific question, is it theft? I do not believe so, because then that would be, you're not stealing money from your spouse, because it's, when you're married, you're seen as one person. So it's both of your money. It's the couple's money. So, I guess I'd have more questions as to where did the money come from. So he said it was from a savings account. Is that right?
Yes.
Is this a savings account that you both are named on? Because at that point it's a joint account. You both have, rights to the account. I don't think you have a criminal case per se for theft. But I definitely think if you're proceeding down the road to divorce or you're in a pending divorce case, first of all, if this is a pending divorce case, we put in either stipulations or court orders once divorces are filed, at least in the states that I practice in. It's called a non-hypothecation order. And what this does is prevent this very thing from happening. Or if it does happen, you have recourse against the other spouse. And a non-hypothecation, essentially what that does is it says, while you are going through this divorce, you can't dissipate your marital assets. You can't go out and buy a $300,000 property with marital money, because now, you've now taken a big lump sum of what the marital estate is. And a portion of that is the other parties, the person who didn't know that this property was being bought. So there'd be recourse in that case. So, I don't necessarily think it's theft to the specific question, but I do think it would definitely be relevant to the court that it was done without the other person's knowledge. And I definitely think you'd have recourse to get that marital money back, or at least, the other thing is that when property is purchased during the marriage, it makes it marital. So I think, did you say that this property was bought in a different state than where they reside?
It did, yes.
So that has a little bit to makes it a little more complicated, because you're not in the state where they reside. However, doesn't negate the fact this is marital property. And if she's going to do anything with this property, it's still marital, and both spouses would have to with the title companies and things like that. Just because it's titled in one person's name doesn't negate the fact that it's marital.
Yeah. And I'll kind of give you what I would do, Mike. Missouri, I mentioned anything acquired during the marriage is marital property. So it's not as if the 300,000 is gone. Worst case scenario is, in the way I look at it in Missouri, if this were Missouri, it goes on her side of the ledger. She has now a $300,000 asset on her side that is subject to division by the judge. Now, yes, you've lost 300,000 in cash, but if we know that marriage or divorce, you're going to probably be you're winding up with less than you started. So from a court's perspective, they're going to look to divide all the assets equally. They can deviate from that 50-50 at some point. So it's what I mean that is when I say that 300,000 goes on her ledger, you will get particularly, let's just assume for the moment you have nothing else, no other assets whatsoever. She's going to have to figure out a way to pay you $150,000 to reimburse you for the money that she's taken. Now, as Samantha intimated, I also would argue to the court that we have financial misconduct. She went and purchased a home, didn't let us know. We found out accidentally, kind of the financial misuse of funds. Try to skew the division. Get the judge, again, they're derailed by emotion. Get the judge to be unhappy with her. Ask for attorney's fees. Those are the types of things. Now, your state in North Carolina may view it a little bit differently. Not sure what the property laws are. Everyone is a little bit different. So again, I would encourage you, Mike, get a consult. Best probably even 30 minutes of your time is to schedule something. We have offices in North Carolina. You want to do that and just talk about what your options are. But it really is, if you're not considering the divorce, but you're just going to live separately, that's a whole nother issue. You may want to look into whether a legal separation is a separate vehicle that you might be able to pursue where the marriage is still maintained, but you're still dividing your assets. So that's something I would consider and ask about. But yes, you should be upset, rightfully so, but it's still an asset of the marriage as far as Missouri is concerned. So it's not lost. So that's kind of where I think Samantha's saying it's not theft. It's just maybe financial misconduct. A little bit surprising the title company, even at closing, even though it's a cash transaction, didn't ask. You may want to get those documents. Did she reflect herself as a single person? That'd be interesting. Use those types of facts and evidence to influence the judge to give you perhaps more. All kinds of directions we could go, Mike. So consult's the best way to get answers, best way to get a good strategy developed, depending upon the direction you want to go. So keep submitting those questions in the Q&A section. I would love to get more of your questions. All right, Kellan. This is from Michael. I'm planning on filing by the end of this year and want the cheapest option possible, as we want to keep it cordial and under wraps. I'm reluctant to share finances with the court and would like to retain control over assets which I contributed. While filling out a form in state, I noticed this option. If both of us agree to split, each spouse keeps their personal property they now have. Does it mean the judge will not ask any questions related to income or assets and simply sign off? Do we still need full financial disclosure, including discovery? I'll give you my perspective, but Kellan, go ahead from New York's perspective.
So, Michael, that's a great question. We typically will call those uncontested divorces. Some states may use similar terms. What I tend to tell people is it's always uncontested until it's not. So you got to be careful. If you're not engaging in a full round of discovery or financial disclosure, you may not know everything that's out there. That being said, specifically to your question, will the court accept an agreement between you and your spouse without financial disclosure? Traditionally, yes. If a settlement agreement is drafted, properly executed, and signed by both parties, courts will normally accept them. Now, they're always open for court review to approve or deny. My history suggests that if there's no kids involved, there's no children, then courts are less likely to scrutinize agreements such as this, because the court's going to look at it as you're both grown adults, you're both competent, and you've made a contract, you've signed a contract, and it is a legally binding contract in most states. In New York and in Tennessee, it's that way. So do you have to get into the nitty-gritty of the financials? Technically, no. If you both know what you want, put it down in the form. If your state has a complete form that you can review, then you can do that. But like I said, I always caution people that it's amicable until it's not. And you got to be careful, because if she has assets that you are unaware of, then a court will expect you to have done your due diligence, done the research. The one thing I would add at the tail end of this, though, is most agreements will have some kind of language that says you have both disclosed all known assets and debt. In that agreement, you both agree to that. And so that can control a little bit down the road if someone was hiding assets, which you should not do, absolutely not, then that can come up, because the other side may say, well, wait a minute, we both agree that we disclosed everything and one person didn't. Yeah. So kind of a long roundabout way to say most courts will accept agreements, uncontested as they were, from litigants.
Yeah, and it gives me a little bit of pause, because let's just assume for the moment that neither of you hire attorneys. There is the fraud notion that if you didn't disclose everything, and years later down the road, because keep in mind the statute of limitations, and even there's a rule in Missouri that doesn't allow, you can go back and set aside something for fraud whenever. It depends on when you became aware of the fraud. So my point being is, if you're less concerned about your spouse knowing and more concerned about the court, then I think you fully disclose. In Missouri, you're going to have to fill out a statement of property, which outlines everything you own and every debt that you owe. So if you're really not concerned about your spouse and they know everything, then I would file it. This is my 30th year of practice. And in that 30 years, I've had one case rejected by the court. And that was rogue. The judge just was in a mood, didn't like it, and it was crazy. I've never had it happen. And that judge and I had words, because here we have, again, two adults consenting, full disclosure. They know what they're doing. And he just decided, no, I'm not going to approve it. I'm going to find it not reasonable. I lost it. Now, that's my point. To me, it's not worth the risk, Michael, excuse me, to not disclose your assets. Again, can't hide it. And if you're trying to get your spouse to not see it, it's a whole set of problems that you just don't want to go down that road. It's not worth it. It just really isn't. So it can be just as quick and easy with a full disclosure. You file it. That's where I would go, Michael. All right. Let's go to Samantha and the next question. Sean says, I've been planning to take my children on a vacation out of the country for several months. I discussed it with my ex-wife extensively. Her condition was that I would need to allow the kids to call her once a day to check in. Recently, flight prices dipped and I reconfirmed. I have both her agreeing verbally and via text. We agreed that after I booked flights, we would create a document with details that applies to this vacation only. I booked the flight on Friday, and now this morning, she's changed her mind, is not going to allow them to go before I could get the form filled out for her to sign. Do I have any sort of legal recourse or for the cost of tickets, or what do I do?
It's a common question, unfortunately, when this happens. So, I'm going to assume here that these two have a parenting plan in place. Your parenting plan covers as much as possible. Your parenting plan covers holidays and certain notice that's given for when you want to take children on vacation, because it is in the best interest of children that they travel and experience new things. So just the understanding that parenting plans can't possibly cover every scenario or argument or situation that's going to happen between parents. So it's encouraged, and it's often language in your parenting plan that says, if there's mutual agreements among the parties, that's fine to venture outside of maybe what's specifically in your parenting plan. If there's been a meeting of the minds, essentially, there's been, especially because here we have not only did you two discuss this, but it was also a text message. So it's in writing that she agreed to this and you acted on that. You not only agreed to this through a conversation, which is good co-parenting, you also had a confirmation from her that, yeah, go ahead, that this is fine, that you can take them on this trip. And vacations are cheap. So now you've spent all this money, you booked the flights, you probably booked the hotel, what have you, and now you're out money and out this vacation. It's also harmful to the kids if they already thought they were going on this vacation, and now you tell the kids that you're not going on vacation. So the answer to your question is yes, you definitely have legal recourse. There was a mutual agreement among the parties, and my advice here would be a contempt action against the mother for not enforcing this agreed upon parenting time and vacation. If the vacation has not come up yet, if it's still, if you still have time to get to court and get the court to enforce the vacation, you can do that. And at that point, I'd be seeking fees from her because you shouldn't have had to file this contempt in the first place. If unfortunately the time has passed, the vacation is over, what I would instruct the client to do is, we are going to file that contempt action, show the court that she's not following the co-parenting agreement, that there is proof there was this agreement, asking that she reimburse you for the fees that you've spent, the attorney fees that you've had to spend to now enforce this agreement. And so, yes, I do think you have that special recourse. I don't think small claims court is the right action to go because you already have the district court, or in Nebraska, it's the district court that's handling these cases. Your judge is in the right spot to enforce this and give you a remedy.
And Sean, I mean, typically if I have a client and they can show and verify that there was an agreement, typically in text and writing, I'm telling Sean to go, yep, take the vacation. And if she tries to interfere with it, then that'll actually provide even better recourse. So I wouldn't lose out on the money. I would just say, we're going, you had an agreement. I've now made the purchases and we'll contact you every day and see what happens.
Absolutely.
Yep. Real quick question came in and I can probably get through this one. This is a question about an immigration visa with the child has been taken to India. This person lives in California, wants his son to stay with him in the United States. What are the chances to get the son back? This is a great example of the need to have a consultation, but I can tell you, I was just looking real quickly off camera. It does not appear that India is a part of the Hague Convention, which is used to try to retrieve children who are removed either unlawfully, without agreement. There's no bilateral agreement between India and the United States that I can see. I did a very, very quick. So again, you can't take that as true gospel. What I'll say is an actual, but I just did a very, very quick look. I would suggest you schedule a consultation with one of our attorneys in California. We have offices throughout California. They will certainly give you some good direction. We've done this before. I know particularly recently we did one in Russia before the issues in Ukraine, and we were able to successfully bring the child back. Now, obviously, Russia becomes a whole different story with the issues that are between the United States and Russia and Ukraine. So it complicates things, but certainly Hague Convention makes things a little bit easier. I would go ahead and set up a consultation. All right. Keep submitting your questions. We just have about 2 or 3 more minutes. Let's go, Kellan. Let's look at from Chris. Or actually, no, let me get to Jonathan. Submitted it. Jonathan says, my 15-year-old is trying to refuse my weekend pickup. He's using the excuse that they want to see friends. This isn't the first time. It's now becoming a habit. I've been trying to communicate with my ex about this as well. I asked my ex to talk to my son, but tensions are high because of our custody and support modifications that are being taken now and going back to court. How hard should I press? I normally get every other weekend. Will this count against me in a custody time allocation? Kellan, what do you say?
Chris, it's a good question. Unfortunately, it's a question that comes up a lot. What I would say is you do have rights as to your visitation. I don't know of many courts out there that would say that a minor child should control visitation because, as we all know, teenagers may change their mind at any given day. It is the responsibility of each parent, traditionally, to enforce the visitation. Now, I know that is easier when a child might be, for example, my daughter's 4, much easier if I'm having a visitation, but for a 15-year-old, it does become more difficult, but each parent usually agrees, whether it's a parenting agreement or ordered by the court, to enforce whatever the visitation schedule might be. If your ex is saying, I'm not going to do anything, he's making up his own mind, I think you do have to go back to court. I know you said in your question that court was going to be coming back this year. Sounds to me like you might want to bring it back sooner because while it shouldn't be held against you, if your son is not exercising the time with you, you don't want to let that just lie, because a court might ask, well, sir, why didn't you come to court? Why didn't you bring it to our attention? And so I would say that if you know you're going back to court already, I would go ahead and bring something, because you can't just let that continue. Unfortunately, it is going to be difficult. You're going to have to work out some issues, but without court enforcement, what are you going to do? And if she's not enforcing the order and you've been trying to, then I think, unfortunately, you are going to have to get the court involved.
Yeah. I was just watching a video that our client had taken, the very same issue, 15-year-old. He's in the car and he doesn't want to get out and doesn't want to see mom. And she calls the police. Police say, look, we're just going to let the court deal with it. And so it is, I think, as Kellan said, you don't want to let it sit. I think it's worthy of getting domestic relations or something, some social workers involved to help you facilitate what that is. And you just can't. I think it's more being proactive, and it may not solve the problem, but it looks like you're not consenting to the problem. And so I think that's the thing, is just take action, stand up for your rights, try to enforce them. You can't force him. You just get someone to figure out where's the middle ground. Where can I get my son to try to find time where it's okay to exercise those rights? Otherwise, if it goes on, you're going to lose those rights, especially if you're going back to court. The judge may just change them. So it's worth fighting for. So that is all the time we have for today. Continue to submit your questions every time we have a virtual town hall. Love to have them. Or you can watch our podcasts. We have podcasts where we are on iTunes on all kinds of issues. You can go to our YouTube channel, where we have virtual town halls like this, full seminars, and our podcasts sit there on our YouTube channel. Again, you can reach out to us at CordellCordell.com, schedule a consult, or give us a call, 866-DADS-LAW. Check out our social media. Keep an eye out for all of our upcoming virtual town halls, the topics related to those. But go ahead and subscribe on Apple iTunes to our podcast. You get alerted every time one drops. We'll have an issue that I know pertains to you. Until next time, have a great week.